All right, let's take up one of the last things you'll have before trial, but really a settlement, a dismissal, and alternative dispute resolution. Settlements, dismissals, and ADR can pretty much occur at any time in a case, before, during, or after a trial, during appeals, after final appeal. Basically, you can always settle. So a settlement is basically known just as the agreement that terminates a civil dispute. There are lots of factors. Why might you consider settling? There's just mainly it's time and money, for that matter. You can look at the tactics of the party. Are they just going to outspend me? How long do I have to live? Am I going to how much are my damages really? What are my chances of winning? What are my chances of losing? That's probably more important than the winning part. Does the judge like me? Is my counsel as good as the opposing counsel? Does the law favor me, or is it kind of a new question? All of those factors come into making a settlement. Realize you can always make a settlement. Also, there's an important thing to know about settlements and really the whole civil litigation process, the rules of civil procedure. It is my opinion, and it's not mine alone, that the whole purpose is to resolve disputes without trial. So the entire rules of civil procedure are more or less written in order to resolve disputes without trial. We are constantly encouraging settlement, compromise. Mediations are mandatory in a lot of places. The whole point is to avoid that trial, that costly, time-consuming trial. When you can get a mutual resolution that hopefully you both are okay with. As they say, a good settlement is one where neither party's happy. They don't mean they're both unhappy. They just mean they're not both extremely happy, or one isn't extremely happy and the other one's not at all. That's what really a trial will get you sometimes. It's a winner take all process, typically, the trial is. So you either win or lose. You get no middle ground. And that's what settlements can do for you. And that's why ADR, alternative dispute resolution, is really picked up and all those things. So how do we go about settling? Well, you can always just make a settlement offer. If you've ever been in a car wreck, and let's discount the personal injury piece, you damage my car, I got to have body work done on it. I go to the other side gives you their insurance information. You make an appointment with the adjuster appraises the value of the repairs, all that stuff. They make you a settlement offer. Usually they give you a check on the spot, right? They give you a check. There you go. You don't have to take it, though. You say, I don't know. But that's the first settlement offer. In the rules of civil procedure, so we get that and we disagree with that, and they usually will resolve it. They don't want to get lawyers involved in the civil litigation, all that stuff. But if they don't and you don't resolve it, and usually when you have personal injury too, you just keep moving through and you file a civil case, and then the discovery process then becomes pretty set up. If you remember, there are these mandatory conferences in the federal rules that require the lawyers and the parties to get together early on in the case to discuss agreeing to as many things as they can. And there's the mandatory disclosure requirements and all that stuff that's aimed towards getting a settlement offer. We also have settlement conferences. Some judges will actually call you into their chambers. In the federal system, they have what's called settlement week every month. So if your trial's set in a particular month, usually there's some other one in the trial schedule that is called settlement week in the federal system. You show up, and that's the week the mediator's there, or usually it's a magistrate which handles a lot of the details of your discovery process to answer those discovery questions, those general application of law and some of that stuff, to get parties to settle during settlement week. And so that's what settlement conferences are. Judges will pull people in. I worked in the circuit court, and the judge I worked for, he was a big fan of mediating cases, usually with the hammer of the jury sitting in the jury room waiting on you to come in. Can get a lot of people to settle because they know, oh, it's really real at this point, and here the judge is telling you whether or not your case really has, sounds good from a more neutral person. Granted, remember, the judge is not the determiner of the facts in a jury trial. They're the determiner of the law, so that doesn't really influence, what the jury is going to think about the facts. But settlement conferences, a settlement agreement is sometimes known as an accord and satisfaction. or a compromise, or it's a contract though. In any event, there's still the four elements of a contract, which is mutual assent, consideration, capacity, and lawful purpose. So you have to have all those things. Another big piece of a settlement agreement has to do with the releases. I release this, you release both parties from any further involvement in those particular fact situations. They can be pretty detailed, but there's always a release because I want it to be clear what I'm giving up. If I give you money, you better not sue me again. That's the whole purpose. As part of the settlement agreements, we got to dismiss the case. So you agree to dismiss the case and to never bring it again. And what they sometimes call global settlements, all those kind of things. The releases are in there. There are different ways to dismiss a case, a civil case. The first is what you can always do, a stipulated dismissal. And that usually is the result of a settlement agreement. Both parties stipulate, means they agree with one another that the case can be dismissed because, you paid me and I paid and I've agreed to do this and you agreed to do that. And now we're both agreeing that the case no longer has to go forward. That's a very common way that cases are dismissed. Another is a voluntary dismissal on notice. That is when if a plaintiff has filed a lawsuit and the defendant has not filed an answer yet, the plaintiff can just withdraw the case, basically, just dismiss it on their own without asking the other side. Usually they notify the other side that, hey, we're not going to do it. Why might you bring a case that you're going to subsequently dismiss? One of those is statute of limitations. Another is the very basic that once I filed the suit and I served it on you, now all of a sudden you're willing to pay up. So there's no point in you even getting involved in it. We agree before your time to answer. Let's not waste the time. Bam, we file I just voluntarily dismiss it. A court can involuntarily dismiss a case. Usually that's because one of the parties has failed to proceed. We sometimes know that as failure to prosecute. You can fail to prosecute even a civil case, which means move forward with it. A court can just kick it out and say you haven't done what you shouldn't have done anything with it. So plaintiff, you're dismissed. A dissent decree is usually it's a common one in a civil case, especially when it's gone on a long time. But basically, a decree is another word for order, which means who signs orders. Usually, judges do. So the parties basically agree. Sometimes they know as agreed orders. The parties agree to set forth some of the basic terms of the agreement, or at least mention that they've done an agreement, and then the court signs off on it. And the court's usually happy to do that because then they're not going to have a trial. And remember, like I said at the beginning, civil litigation, civil rules of procedure, I think, have been designed to really encourage foster settlements. So that's settlements, that's dismissals. ADR is the alternative dispute resolution, is the last area in this section, and it relates really to, again, this formalized process of trying to get people to mediate, settle cases, resolve them without trial. You know what negotiation is, you know what mediation is. Non-binding arbitration is kind of like mediation, but it's a neutral person hears your case and gives you an opinion. Non-binding means, though, that you can still take it to court and all that stuff. Binding arbitration is the opposite, or it's not the opposite, same thing, but now it's binding in the sense that you can't go to court. You can only argue over a handful of things in a binding arbitration. Baseball arbitration, and it comes obviously out of Major League Baseball, is where both parties, usually in that case it's the team and the player, cannot come to an agreement on the amount of salary. And what they do is then the player brings forth their number, their salary number. Team brings forward their salary number, and they present their arbitration to a panel of arbitrators. And the arbitration panel has only two choices: to accept the team's salary or the player's salary. They hear the arbitration, they pick one. That's what baseball arbitration is. Okay. In true baseball arbitration, both sides know what the other side's number is. So just so you know. So the next one is night baseball. And night baseball basically means it's secret. Your number's secret. The player's number is not known by the team and vice versa. Same thing. The arbitrators only have the option to pick. They usually pick. They then make an award, so not even the arbitrators know. And whichever number is closest to the number they have, is the one that is picked. Okay, so again, the team puts forward their number, the player puts forward their number, and that's all that there is. There's no, the arbitration panel doesn't decide the number. It ends up picking one or the other, more or less. Okay, there's two more, med-arb and arb-med. Med-arb is mediation arbitration, and vice versa. Mediation arbitration is where you basically are mediating, knowing that there is this, the hammer of a binding arbitration coming. It helps incentivize the parties. It's like I said earlier, with the hammer, the jury sitting in the jury room waiting on you to start your trial, is a powerful incentive to settle your case. That's the concept of med-arb. Arb-med is basically the other way of that, and arb-med is where you put forward your arbitration. The arbitrator puts forward an award, but it stays secret while the parties then mediate, and the arbitrator is involved in that mediation, knowing what the arbitrator is going to do, but the parties do not know what they're going to do. And if they can't resolve it, then the arbitration award stands. Again, the whole idea is to leave that hammer, that pressure to settle. Okay, so that's this section.